Discuss you live to this. The Constitutional Court hearing challenges to the Electoral Amendment Act today. One SA and the Independent Candidates Association have launched this application. Let's listen in.
Constitutionality. So like Michael had mentioned, we're here because there's a number of constitutional issues which are represented by a number of different organizations. One South Africa is focusing on two elements, one being the signature requirement, which, as Michael has explained, imposes a significant barrier of entry to participate, which is obviously a violation of rights such as equality, but also the political rights of independent candidates to participate. And then the second one deals with vacancies, but actually it comes down to the fact that this new electoral system literally throws votes away, and not just two, not just three, but you can anticipate that hundreds of thousands, even millions, depending on the popularity of a specific independent candidate, will essentially count for nothing. It will be thrown away, discarded, and that is a serious injustice. There's people who literally died for everyone to have an equal vote, but also for that vote to count equally in the composition of parliament. And so we can't actually accept any political system that says that your vote, because it's towards an independent, counts less. So that's actually the essence of the constitutional argument when it comes to vacancies and the sort of technicalities around that specific issue.
Dr. Louis, regarding some of the amendments, particularly with the National Assembly, you're asking for the 50-50 split to be removed and for there to be 350 for regional and 50 for compensatory. Appreciating that could take some time for Parliament to remedy that defect that you are calling out. Could this mean that we could go to another election without independents actually participating in a manner which they see as fit for purpose?
Well, look, I think that's the arguments in front of the court. You know, we're asking that the split should be 350-50, and the reason for that is because our actuarial submissions to the court today that show that instead of independent candidates having to achieve 90,000 votes instead of the 45,000 votes to get a seat in Parliament, the 350-50 makes it that the independent candidates and parties each have to only get 45,000 votes. So to me, as chairman of the Independent Candidates Association, I'm really struggling, because if an independent candidate comes to me and says they want to stand as an independent candidate, it's very difficult for me to encourage them to stand if they must get 90,000 votes. So we're asking the court to do a writing in clause to make a judgment. And if the Constitutional Court makes a judgment and a writing in, it's very easy that Parliament just goes back and amends the Act, and that could take 1 or 2 months.
Thank you. Yeah, sorry, I'm just rushing to go inside, so we'll ask questions throughout. Thank you so much. Thank you.